And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
The Supreme Court just delivered a procedural sledgehammer to the entire federal judiciary. This 6-3 emergency order, delivered swiftly and without the typical full oral arguments, completely prohibits lower courts from issuing nationwide injunctions that freeze state or federal policy across all 50 states. It's an immediate, seismic correction to how legal battles have been fought for the last 2 decades. The core decision is this: a single federal judge can no longer issue a blanket decree that affects millions of people who were not specific parties in the lawsuit. This might sound like dry legal housekeeping, but the scope of the impact is difficult to overstate. In the last 10 years alone, judges have issued over 60 of these sweeping nationwide injunctions. This allowed individual district judges, often strategically selected through a tactic called forum shopping, to single-handedly override the policies of entire state legislatures or federal agencies. What the Supreme Court just did was declare this entire practice unconstitutional and effectively slam the brakes on 47 active cases where states were relying on this exact mechanism. To understand why this ruling goes so deep, you have to look past the policy implications and focus on the forgotten history. The constitutional reasoning cited by the majority, particularly Justice Gorsuch, relies on a historical analysis showing that from 1789 through 1850, federal courts never once issued an injunction that applied beyond the specific parties actually standing in front of them. He references 12 founding-era cases where judges explicitly rejected broader relief, even when efficiency was cited as a reason. The majority's point is clear. The concept of the nationwide injunction has zero constitutional foundation and was essentially invented by modern courts out of convenience. Justice Thomas went further, pointing directly to Article 3 of the Constitution. Article 3 limits federal judicial power exclusively to cases and controversies. By definition, this means resolving specific disputes between actual, named parties, not resolving abstract policy disagreements affecting millions of people who haven't even been sued. The dissenting justices warned that this interpretation would dismantle the legacy of crucial civil rights cases from the 1960s, but the majority treated that as a flaw in the old procedure, not in the Constitution itself. This focus on procedure means the rights you thought you had may suddenly depend entirely on which state line you are standing near. Before we dive into the specific chaos this is already causing in election law and civil rights, take a moment to hit the like and subscribe buttons. The fallout from this decision is evolving by the hour, and Law Advisor is here to break it down. The political earthquake started immediately. Within hours, attorneys general from 12 states issued emergency filings citing this new ruling. Texas referenced it in 3 separate lawsuits challenging federal immigration policy. Florida invoked it in cases involving election law and social media regulation. The speed of these responses tells you that state strategists knew instantly this was the legal weapon they had been waiting for. Internally, the White House counsel's office is advising federal agencies to prepare for state laws they thought were frozen to suddenly snap back into force, possibly as soon as next week. Republican governors are announcing plans to enforce previously blocked policies. Democratic state attorneys general are scrambling to figure out how to protect their residents from policies in neighboring states that they view as harmful. This ruling completely rewrites the playbook for federal litigation. For 20 years, advocacy groups on both sides used forum shopping. They filed lawsuits in districts with sympathetic judges, knowing that one favorable ruling would lock down policy nationally. Data is wild on this. Between 2017 and 2021, 78% of nationwide injunctions against federal policy were issued by judges in just 5 specific districts, representing less than 4% of the U.S. population. The Supreme Court has effectively killed this strategy. Now, if plaintiffs want broad impact, they must file in multiple jurisdictions simultaneously. A case that previously required 1 filing in 1 friendly district might now require 15 or 20 filings across different circuits. This means separate legal teams, separate arguments tailored to local precedent, and separate appeals for every single location. Major law firms are already circulating memos warning that the cost of constitutional litigation, civil rights, environmental challenges, policy lawsuits, could increase by 5 to 10 times overnight. But the most critical change is what this does to on-the-ground enforcement. Immigration enforcement is the flashpoint. ICE currently operates under 14 different injunctions limiting various aspects of deportation policy, detention standards, and asylum processing. Under the new framework, many of those injunctions might only apply in specific, small districts. This means federal immigration authorities could resume full enforcement in states not covered by the limited orders, potentially within the next 30 to 60 days. Second Amendment cases are similarly affected. Gun regulations in 6 states are currently frozen by nationwide injunctions. If those injunctions are narrowed to protect only the named plaintiffs, state officials could immediately begin enforcing those firearm restrictions on everyone else. Your Second Amendment rights would literally change the moment you cross a state border. Healthcare access faces major pressure too. There are 11 active cases where nationwide injunctions prevent enforcement related to abortion medication, gender-affirming care, and insurance mandates. If those orders are narrowed, we could see policies enforced or blocked based purely on geographic luck. This geographical fragmentation creates a constitutional conundrum. If federal law can be enforced in Texas but not California, or vice versa, based purely on where lawyers filed lawsuits, are we still operating as one country with one constitution? Or have we effectively created 50 separate legal systems? This risk of fragmentation is most acute in election law, which is now facing a time bomb. Election litigation is about to become impossibly complicated, and the timing of this ruling could not be more sensitive heading into a presidential election cycle. Currently, 9 nationwide injunctions affect everything from voter ID laws to mail-in ballot procedures in 19 states. Under this new framework, those injunctions might only protect voters in the specific county or district where the plaintiffs live. The same state law could be enforced in 80% of a state, but blocked in the other 20%. This is an absolute nightmare scenario for election administrators, who need uniform rules months in advance to train poll workers, print ballots, and set up voting locations. The National Association of Secretaries of State has already expressed serious concern about the operational chaos this will create if injunctions are geographically limited right before a major election. Both political parties have lost a massive weapon here, as both conservatives and progressives relied heavily on these broad injunctions to challenge rules they disagreed with. Now, election rules will vary dramatically, not just state by state, but potentially county by county within the same state, depending on the patchwork of limited injunctions that survive. Corporate America is also quietly panicking. Companies that operate in multiple states suddenly face navigating 50 different regulatory environments, where federal rules might be enforced in some jurisdictions, but not others. Compliance costs for multi-state businesses could increase by tens of billions annually if they need to maintain different operational standards in different jurisdictions based on the geographic scope of limited injunctions. Banking regulations, cryptocurrency rules, consumer protection standards, and data privacy requirements are all currently subject to broad injunctions that may soon create confusion in technology and financial sectors. But perhaps the deepest philosophical issue is the civil rights complication. Civil rights organizations warn that limiting injunctive relief forces victims of discrimination to fight the same battle in dozens of different courtrooms before achieving nationwide protection. They point out that during the civil rights era, nationwide injunctions were crucial in cases like Brown versus Board, prohibiting segregation across entire states, not just the specific school districts that happened to file suit. If those cases had been litigated under the new framework, desegregation might have taken decades longer, requiring separate litigation for every single local school board. When a state passes a law that discriminates against a protected class, should the relief be limited only to the handful of brave plaintiffs who came forward? Or should it protect everyone in that class throughout the jurisdiction? The Supreme Court's majority opinion avoids this tension, focusing purely on the Article 3 limitations on judicial power, regardless of the sympathetic nature of the claim. Disability rights advocates are especially worried, noting that the Americans with Disabilities Act has been enforced largely through broad injunctions requiring systemic changes to government and public services. It is deeply unclear how systemic enforcement works under a regime of plaintiff-specific relief. The final, and perhaps most significant aspect, is the Supreme Court's power play. By issuing this ruling through the emergency shadow docket, rather than waiting for years of full briefing and oral arguments, the court sent an unmistakable message that it expects immediate compliance from the lower federal judiciary. This is the culmination of a pattern where the current Supreme Court has used its emergency powers to control how lower courts operate, essentially micromanaging federal litigation and telling hundreds of district and appellate judges they have been doing their jobs wrong for 2 decades. This assertion of power is reshaping the entire judiciary from the top down. This Supreme Court ruling changes everything about how federal power operates in America, and we are just seeing the beginning of the fallout. Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget, knowledge is the ultimate defense. I will see you in the next one.